May I please, Lordship. Lordship, may I beg to mention item 5 and 6, criminal petition. Lordship, here the petitioner counsel and the respondent, we are making this prayer jointly. So, Lordship, this matter may be listed after one. Today we have some personal difficulties. 4 and 5.
4 and 5.
Yes, Lord.
5 and 5.
Lordship, 5 and 6,
It's
Lordship.
5 and 6.
Yes, Lord. 5 and 6.
Okay, you're for respondent.
I am for respondent number 2.
You're for petitioner.
Yes.
Please.
Okay. On the joint prayer made by both the land council for the parties, list this matter
After
after
1 week.
a week. Okay.
Deeply obliged.
May I please, my lord.
Yes.
My lord, I beg to mention item number 17, the civil revision petition. Conducting counsel for the respondent, Mr. Tony Patton, is out of station. Can it be listed after 4 weeks?
Okay. Have you informed the petitioner?
My lord, I have not found the petitioner. I don't have their
Then
contact.
what we'll do, we'll adjourn, but wait for some time.
My lord,
You
I
can
put,
tell someone, anyone else. You're
I put
for
a petitioner. Yes, sir.
No objection.
No objection. Item
Okay.
number 17. Pardon.
Okay.
Any objection? No.
Mr. Jam, land council for the land council submits that the conducting council for the respondent.
Sole respondent.
So respondent is out of station. Therefore, pray for adjournment of the matter for a week or two.
4 weeks?
For
3 weeks. 3 weeks, my lord.
For 3 weeks, which the land council, Mr.
H-tie.
Land council appearing, land council appearing on behalf of the respondent, sorry, petitioner has no objection. Prayer allowed, list this matter after 3 weeks.
Highly obliged, my lord.
May I, Lordship, I beg to mention item number 28. I'm appearing on behalf of Mr. Pitapo.
22,
28, Your Lordship.
28.
28, yes, 28. Lordship, the conducting council is out of station, so this matter may be listed after a week.
This is the one I was ready to. You're for the petition, appellant
Yes, yes. I have taken the consent.
or consent. Okay. Miss
Tirini,
Submit, that's the conducting council, Mr. Pritam Tapo. Land council for appellant is out of station, therefore pray for adjournment of the matter for the day. She has also obtained consent from the land council of the other side. Accordingly, the prayer is allowed, list this matter after
a week, Your Lordship.
a week.
May I, Lordship?
Yes.
Lordship, I beg to mention item number 27. My senior counsel is out of station. Lordship, I have taken consent from the other party. This matter may be listed after puja vacation, Lordship.
Yes.
27. 27.
Okay. You're Mr.
M. Lago
M. Lago,
on behalf of UDECA.
land council submits that. Similar to the M. Lago, huh? Mr. The conducting council, Mr. Udeka, land council for the appellant is out of the station. Therefore, pray for adjournment of the matter for the week. He has also obtained consent from the land council of the other side. According to the prayer is allowed, list this matter after
Puja vacation.
4 weeks.
Obliged, Lordship.
May I please, my lord. May I humbly pray, item number 21, 22, 25, 26, my lord.
Okay.
I beg to mention that, my lord, it may be listed after 2 weeks, my lord.
Yes.
Yes, my lord.
The hearing-
Hearing list, my lord. In fact, my lord, I have spoken to Mr. Tang, my lord.
Okay.
He was supposed to mention the matter, my lord, but
Okay. Mr. Popada, land council appearing on behalf of the respondent claimant.
no, my lord.
Respondent.
Yes,
Respondent.
claimant, my lord.
Okay, claimant. With the consent of the land council for the appellant, pray for adjournment of the matter for
2 weeks, my lord.
2 weeks. Prayer allowed, list this matter after 2 weeks.
Deeply obliged.
Okay. You will be lose. Okay.
Lordship, I beg to mention item number 4. Lordship, I'm for a respondent here in this case, Lordship. I have taken the consent from the petitioners also, Lordship.
Okay,
This matter may be listed after two weeks, Lordship.
Mr. Jungam Jini, Land Council for the respondent. With the consent of the Land Council for the petitioner, pray for adjournment of the matter for 2 weeks.
2 weeks.
The prayer is allowed. List this matter after 2 weeks. Okay.
Right.
Item 1, Mr. Lord.
Lordship,
Yes.
Lordship, the petitioner filing this CRP.
So
Will-
you have any, this one? Gift deed to
Regarding transfer,
your mother executing any gift deed in favor of brother?
her younger brother.
Is there?
No, I have not annexed, Lordship.
Why? That is otherwise important documents, even in the later stage also,
Yes,
in
that-
order to show.
yes, but that has been, that has been clearly spoken to them, intimated them regarding, and it was way back in 2015, transfer was done, already done. And regarding, Your Honor, that regarding possession of land also by non-native, the provision is very clear. Even in case, assuming, Your Honor, for a time being that the petitioner has possessed, that case also, they cannot summon the petitioner
No,
for
now because if the land is still in the name of his mother,
transfer process has already initiated regarding the LPC trust.
have you annexed?
No, Lord. That documents, Your Honor, I have not annexed is because that information, that fact has been already stated before the Blaze Authority and the complainant also. That I don't have possessed any land. The land is with,
Now, his allegation is that you are trying to sell the land.
yes. Yes,
Whereas you have
their
not-
allegation.
And that this land actually was not given to your father. Not sold to your father. It was given, so not sold, but why it was given? The land, what is his allegation?
His allegation is, Your Honor, his father and grandfather did not sell any land to the father of the petitioner.
Okay, this land is under whose possession now?
Now, Minjam Padu.
Are they staying in the place, in the land?
No.
Okay, no one is
It's a
staying,
Jum land, yes.
it's June land.
Yes, Your Honor.
Okay.
It was already transferred in the year 2015 on the basis of declaration made
Now,
by the.
during this period, and 76 probably, 1976? it was-
Yes.
During 1976 to 2000.
Yes, nothing.
Till the date of your mother.
Yes.
Who were cultivating.
Yes, cultivated, Jum land.
You were cultivating.
Yes. Mother was
So
cultivated.
there was no complaint.
Nothing, Your
Nothing.
Honor. Nothing. Even the father of the complainant is still alive. Father, he is also the GB, but he didn't raise any objection. But it is the grandson,
It was sold by his father only.
grandfather. Complainant,
Grandfather, not by the
yes,
father.
yes, 1978, Your Honor.
78.
78.
Okay.
The petitioner,
So
this
he
is,
says that it was not sold to the father, but then your contention is that it was purchased by your mother.
mother, in the name of mother. Therefore, LPC was also obtained in the name of
Mother.
this is mother, yes. Accordingly, subsequently, it was transferred to his younger brother.
Will issue notice?
Issue notice and Lordship, I have some prima facie case, Your Honor, on two grounds. First, Section 7 does not allow me to possess any land. If in case the allegations are to be true, they have another forum to challenge my possession. Otherwise, I made a specific averments in my application petition, Your Honor, that I don't have possessed any land. And another ground is, Your Honor, in terms of Section 40 and 27 Clause 7 of Civil Codes Act, no indigenous can be called before the governed by the Blaze Authority, Your Honor. Despite of that, this law, they are issuing
No authority can issue. What did you say?
non-indigenous.
Non-indigenous.
Yes.
It's only within the.
Within
Only
indigenous, yes. The parties must be indigenous to that particular place. May I show you the Section 4, FR 40, Your Honor?
What's that?
FR.
Yes. Or Mr. K. Lole, Land Council for the petitioner.
And Civil Code Act 2021.
Hmm?
Civil Code Act 2021. Huh. Under Regulation 40, Your Honor, the language is very clear. The blessed authority shall try all suits without limit of value in which both the parties are indigenous to the Union Territory of Arunachal Pradesh. And here, 2021 Arunachal Civil Code Act, let's say Section 27, sub clause 7. Here some amendment has been made under Section 40 of AFR.
Amendment of the, yes,
Yes, on Roman 7 also. Here some entry has been made. In Section 40, Regulation 40 of AFR, there was a two condition. First, the party must be indigenous, and then the party must be live within the jurisdiction of that Gauburas. And that within jurisdiction has been deleted and by this Civil Code Amendment Act, which provides that the blessed authorities shall try all suits without limit of value in which both the parties are indigenous to the state of Arunachal Pradesh.
the petitioner has filed this application under Article 227 of the Constitution of India, seeking setting aside the impugn second for Vana, PORWAN, dated 5/6/2025, issued by the Customary Court of Gori Village,
Yes.
Leparada District, Arunachal Pradesh. Directing the petitioner to appear before Keba. This is Keba, not Keba. There are two. One tribe called Keba. The other tribe, this is Keba only. Yesterday you wrote Keba only. This is Keba. Huh? Sorry, Keba. To be held on 2/7/2027.
Yes.
2/7/2027. This is the only challenge?
Yes.
Okay. Para. The case of the petitioner is that his mother is an indigenous tribe of Arunachal Pradesh, married to his father, who is non-indigenous of Arunachal Pradesh, staff, huh? In the year, which year you said? 1976 to 78.
76 to 70.
His mother. What is the name of the mother?
Let Minsa Bagra, MINSA, Bagra.
Ucha Bagra. Late Li. Right, huh? Bagra.
Minsa Bagra.
Out of her own hard-earned money, purchased a land from the grandfather of the respondent.
Yes.
From the-
Actually, that particular land, she purchased from 4 owners.
Okay, purchased a
For
land
another tree is
and
not complete.
land. And from 4 persons, have you stated?
Yes,
Okay, land from the 4 land owners. And in the year 2000, in which year you obtain land possession certificate?
LPC Lordship 2000.
And
2000.
obtained land possession certificate in the year 2000.
Yes.
Stop. It is submitted that during her lifetime, his mother gifted the said land to her brother.
Yes.
What is his name?
Minjam Bagra.
Minjam Bagra. Is the petitioner and his father being a non-indigenous of Arunachal cannot possess any landed property as per which
Section 7, Regulation 7 of BERF.
okay,
Bengal.
Regulation 7 of
Yes, Lord.
Bengal. As per the
Bengal Eastern Frontier Regulation,
Bengal Eastern Frontier Regulation,
1873.
1873.
Yes.
Stop. However, recently, the respondent filed complaint before the which authority?
Deputy Commissioner.
It's before the Deputy Commissioner.
Complaint was filed before the Deputy Commissioner
Okay.
for filing for a direction to the place authorities for cover. Accordingly, that complaint was
Okay.
forwarded.
But then this land, he is also praying for the cancellation of the land LPC.
Yes. Cancellation of
LPC,
LPC by way of settlement through the cover. His exact
Okay.
language.
Okay, because the cancellation can only be done
Only
by
be done by
DC,
the issuing authority,
issuing
Deputy
authority.
Commissioner.
Okay. Filed complaint before the Deputy Commissioner, Basar Leparada, praying for cancellation of the land possession certificate issued to the mother of the petitioner through the
Settlement
settlement
at village level cover.
at village level
Cover.
Kebang.
Yes.
The village level Kabaha. The contention of the petitioner is that he is the lane is under the possession of his maternal uncle
Yes.
Sri
Minjam Bagra.
in Jampagra and not under his possession. And as he cannot possess the land, being a non-indigenous
Yes.
of Arunachal Pradesh staff. The further contention of the petitioner is that the village authority cannot issue forwana stroke summon against him as per the regulation 40 of the Assam Frontier within brackets administration of justice bracket close regulation 1945 amended section
Section 27.
section 27. No, this is 40.
Yes, initially it is under regulation 40 of AFR.
Okay,
And-
listen. Now it will be 27 only.
27 sub
Okay.
clause 7.
Under 27 regulation 27 sub within bracket Roman 7, huh?
7.
Which provides that in the village authority shall try all suits without limits of value, comma, in which both the parties are indigenous to the state of Arunachal. Okay. Para. From the above, prima facie, it appears that the petitioner is a non-indigenous of Arunachal Pradesh. The question of jurisdiction of village authority over under the circumstances, the question of village authority, question of jurisdiction of village authority over a non-indigenous person and legality of its order will require detailed consideration after hearing the parties. Staff issue notice returnable by 4 weeks. The petitioner shall take steps upon the respondent by a registered post with 80 within a week from today.
Yes.
Whether record is not necessary.
Not
It's
necessary,
all-
not.
No record has
Yes.
yet been created.
Not nothing,
Staff.
only complaint and this sub
Okay.
forward.
In the meantime, the operation of where is the impugn order?
If you know the lordship, annexure 1 phase 25,
Page
25, 25.
no, this is local. Where is the translated one? 26.
Yes, 26 is the translated.
I've seen something.
Lordship.
Just a minute. Where is the? Are you not praying for the stay of the order by which you are prevented to sell. Yes, what is this order? Are you not challenging this order? 28, page 42. Who passed this order? This is, I think, the order which should have been challenged.
This is issued by the governing authority, place authority.
See, you are not challenging this order.
Challenging lordship, in fact, the whole entire the process of issuing
No.
summon.
See. Both the parties are hereby directed to stop doing any kind of activities like jungle cutting, art cutting. Let us say dispute on Juvenile till the decision of the Keba.
Yes,
Hmm.
status quo has been given. Lordship, this
Directed to maintain status quo.
lordship. Lordship, this order itself will go because the first, the place of I don't have possess any land, and then this is wrongly issued to the petitioner who don't have possess any land, and this order will not affect to the.
Okay, this will not affect you.
No, not affect to the Minjom Bagra who is possessing the land, Your Honor.
Okay,
Yeah. Technically, lordship.
but this is talking about the same land. The stay is over the same land. Maybe it is under possession of your maternal uncle,
Yes.
but then this stay is for the same land. Not to do anything on it.
Yes, Lord.
And this is not in your prayer.
Yes, I have no specific prayer against this order. Because they have wrongly issued and since.
Okay. That means the Orvana issued Orvana dated 5/6. This is a 5/6/2025.
Yes, Lordship.
Issued by head GB Gori Roman 3, District
Yes.
Leparada,
Yes.
directing the petitioner to summoning the petitioner to appear for Keba on 2/7/2025 shall remain state. Okay. List this matter after 4 weeks.
4 weeks. Deeply obliged.
Marvelous, ma'am.
Yes.
This is bail application. The bail application reported lordship is in connection with the Norlogan PS case number 62, wherein the allegation is under section 21B and 29 of NDPS Act. Madam.
Your earlier bid was rejected.
Madam, my previous bill was rejected on 3rd June 2025 only on the ground that it was in the initial stage, and my lord will find in the page
When it was 3rd June.
3rd June
So today
29, page number 29.
is
And
now,
operating
what is the new ground you have taken this time?
and my
Whether
lord
the
will,
status of case has changed?
my lord will find in the page number 6, particularly in the para 9. My lord got
Para
it?
9.
Yes.
What is
So-
it?
My lord, at the time when my previous bail was rejected, at the time, my lord, it was on initial stage. Now it has now the IO has got the ample time of more than 45 days.
Okay, so what is the offense? It's 21B.
Yes, 21B, intermediate, deal with the intermediate
Yes.
quantity of the NDPS.
Yes, call for city map. Case study. Yes, for sure. But see, I mean, council. Not many things has changed because the matter is still under investigation. And this is 27B. Intermediate, 21B. Little difficult. Mr. Modi. C. Modi, Land Counsel for the petitioner. This is an application filed under section 483 of PNSS 2023, praying for grant of regular bail to the alleged accused person, Asraful Islam, who has been arrested
On 8
by the
April.
Nahalagan police in NDPS case number 62/2025 under section 21B/29 NDPS Act. Call for the scanned copy of the case diary. Issue notice. Hence, Mr. Lloyd, Leonard PP, appear and accepts notice on behalf of the state. No formal notice need be issued. Stop. List this matter after
1 week, Lordship. B is on 25, Lordship. 25.
25.
Yes, Lordship.
All right.
25.
Please.
Yeah, please.
Yes.
My lord, this is quashing petition. Basically, the case is that even if the FIR, my lord, is considered as gospel truth also, there is no any case that is made out against me.
Is this a joint petition? No.
No,
Okay. On merit.
on merit.
What is the allegation? Just let us see.
Allegation kindly come page 27, my lord.
27.
27.
No. Where is the allegation? 31.
31, please. Married.
Yes.
This is of 28/5/2025 to the officer in charge, Women Police Station, SEPA. Subject is, my lord, FIR against Sri Jada Singhi, AEWRD department. He is the main accused, my lord. And Miss Asa Meji, TGT teacher, that is me, my lord, for cheating, domestic violence, and attempted polygamy or violation of CCS conduct rules. Respected sir, madam, it is bring to your notice for necessary action, please, that I, Srimati Amak Singhi, wife of Sri Jada Singhi, who is assistant engineer in the Water Resource Department, Government of Arunachal Pradesh. My husband and I have been married since 17 October 2010 under customary law, and we registered our marriage under the Special Marriage Act on 16 September 2023. We have 3 children. Our eldest son is 9 years old. Our daughter is 7 years old, and our youngest son is only 11 months old. Our married life was peaceful for more than 13 years. However, for the past 2 years, my husband has been involved in an illicit extramarital relationship with Miss Asa Meji, a TGT teacher at Upper Primary School, Pagia Valley, Sepa. Despite being fully aware of our legal marriage, this relationship has caused me immense emotional trauma and amounts to mental cruelty and domestic violence as defined under the Protection of Women from Domestic Violence Act 2005 and punishable under section 498A IPC.
It's very
Customary-
long. Very long. I think.
Very long FIR, my lord.
FIR. Anyway, but
Basically, what it says, my lord,
registered under which section?
sections are, my lord, kindly come to page 34. 316.
What is 316?
criminal breach of trust, my lord.
Breach of trust?
Criminal breach of trust.
Okay, and this 85?
Uh, husband or relative of husband of a woman subjecting her to cruelty. That is
So,
as well,
should have filed domestic violence case, isn't it?
my lord.
Whether this was forwarded or just registered?
Just registered, my
Investigated,
lord.
okay. So,
Kindly come to page 11 of my petition, my lord. Because
Page 11.
paragraph 3, I have narrated, I have reproduced the contents of FIR as well as reproduced all the provisions,
Okay.
sections, paragraph 11, page 11, my lord.
yes,
The registered
yes.
second
I'm
paragraph,
having-
sections of the BNS 2023 are reproduced herein below. 3162 BNS is whoever commits criminal breach of trust shall be punished with imprisonment of so and so. That is not attracted against me, my
No.
lord. 82(1) BNS, my lord. Whoever having a husband or wife living marries in any case in which such marriage is void by reason of its taking place during the lifetime of such husband or wife shall be punished with. This is also not attracted against me, my lord. 85B, husband or relative of husband of a woman subjecting to cruelty. This is Arswell 498A, my lord. This is also not attracted against me. And next is 3 BNS, that is at page 12. When a criminal act is done by several persons in furtherance of common intention, Arswell 34, my lord. This is also not attracted against me.
Okay, so now the investigation. Okay, what is the status of the case?
Case is under investigation. The
Still.
main accused also, he was arrested and then he was released.
Who is the
And
main accused here?
uh,
You are for?
I am the co-accused, Miss Asa Miji.
Okay, okay.
And I also, since police have attempted to arrest me, I also approached before this honorable court.
You
And
are
this
granted bail.
granted AV, my lord.
Okay,
Pre-arrest bail on the motion stage itself, it was disposed of, my lord.
okay. So then,
So, my lord, I am placing one judgment that earlier settled proposition of law decided in Bhajanlal's case, my lord.
yes,
That was reiterated in this Ramesh Chandra Gupta. Reported in 2022 18 SCC
Yeah.
706. Kindly come to para 15, my lord. Para 15, my lord, it says the exposition of law on the subject relating to exercise of extraordinary power under Article 226 of the Constitution or the inherent power under Section 482 CRPCs are well settled, and to the possible extent this court has defined sufficiently channelized guidelines to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. This court has held in para 102, that is Bhajanlal's case, my lord. Kindly come to next page. To lay down and precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formula and give an exhaustive
can
list.
issue notice?
My lord.
Call for the.
Case diary, you can copy of the case diary.
Because notice to the respondent. Okay, heard Mr. K. Tama, National Counsel for the petitioner. This is an application filed under section 528 of the BNSS 2023, praying for passing of the FIR
Dated 28/5,
dated 28/5/2025,
corresponding to
the
SEPA Women PS case number 9 of 20.
SEPA WPS case number 09/2025 under section 316 within bracket 2 stroke 85 stroke 82 within bracket 1 3 within bracket 5 of BNS 2023. Call for the scan copy of the case diary. Issue notice. The Saint Miss L. Hage, Lanet additional PP. Appear and accept notice on behalf of the respondent number one. No formal notice required to be issued to the said respondent. However, the petitioner shall take steps upon the respondent number two entry by a registered post with ID as well as by usual process within a week from today.
My lord.
List this matter after.
Lordship, after
Then-
a week, Lordship.
After, then within 2 days, after a week, will it be?
Lordship.
Notice is to go.
Oh, Lordship, notice.
2 weeks, ma'am.
2 weeks, Lordship.
Okay, then you take a step within 3 days, then in that case, okay, steps within 3 days. And this is matter after 2 weeks. Okay.
Highly obliged.
Obliged, Lordship.
This is Lordship, joint criminal petition for quashing of FIR. So here, the FIR was lodged on 33/2025 against the accused person who is a minor. So accordingly,
What is the age of the accused?
14 years,
14 years.
14 years. It is school-going children.
He was arrested
Yes,
during, okay, and sent to juvenile home.
yes, Your Honor.
And then
and
where he is now?
He's,
He's out now.
yes,
out on bail.
Out on bail. Now is in Rajasthan for pursuing his further education, Your Honor.
Let us see the agreement.
Lordship, here, Lordship, the case has already been submitted into PIR, Lordship, for preliminary inquiry report to the concerned juvenile board, Lordship.
Okay, before the juvenile board.
Yes, Lordship. So the investigation is complete, Lordship. So this passing of FIR, Lordship, is not maintainable now, Lordship.
Then you have to challenge this time.
Yes. I have-
Incorporate this.
Yes, I may be allowed, I will file a IA application,
Yes,
bringing this, yes.
bring this on, because
Today only
this-
I came,
this need to be challenged.
yes, yes, Lord.
Must have read after filing of this report, must have registered also. Correct that number
Maybe,
and
maybe,
challenged by way
maybe,
of filing.
yes, Lord.
Because case has been settled and this is to be quashed
Yes,
if it is
Yeah.
to be.
FIR and charge it.
Okay, so after settlement, this was not informed to the IO of the case.
Already informed, even copy was also placed before the IA, but since there is a non-compoundable offense, that's why IA
Okay,
might have
then carry
proceeded.
it on.
Yes,
This is, and as there was also no stay.
yes, yes.
Stay cannot be
Yes,
enforced. But
yes.
when do you want this matter to be listed?
After a week, in the meantime, I will file IA application.
After a week? After a week?
Yes. Because I have to obtain a copy, yes. Have you copy? Copy मिले?
Record is available whether
Lordship, record, Lordship. Lordship, not, we have, Lordship, called for the case study, but Lordship, instead of that, they have produced this,
submitted.
yes, Lordship, we already
not with
submitted.
the IO.
Yes, Lordship. Only, they have submitted already, Lordship, before the juvenile board.
Okay. Mr. Kelole, Land Council for the petition of stuff. Miss L. Hage, Land Addition PP. At this stage, submits that the case has the investigation of the, now after completion of the investigation, the case has already been submitted into. What is this PIR?
Preliminary inquiry report, Lordship.
Preliminary inquiry report. When? On 28/5/2025. And the same has already been forwarded to the Honorable Court of Principal Magistrate Juvenile Justice Board, Papumbara District. Wait, Papumbara is at UPI?
Yes, Lordship.
Yes, you.
district UPR. In view of the above, Mr. Lolan prays for some time to bring on record the prays for some time to file. No, bring on record by filing. What is the number? The charge sheet, not charge sheet,
PIR.
preliminary. What do you call this?
Preliminary inquiry report, Lordship.
Okay. Preliminary inquiry report by way of filing affidavit. Some time to challenge the preliminary inquiry report and to bring on, okay. The prayer is allowed. List is matter. The prayer is allowed. Stop after. You also produce a record.
Yes, records may be called for you.
Okay.
This record.
Yeah, in view of the above, the records from the Honorable Court of Principal Magistrate, Juvenile Justice Board, UPR. We also call for staff.
Scan copy, Lordship.
Scan copy of the preliminary inquiry report of the case from the Court of Principal Magistrate Juvenile Justice Board, UPR. We call for list this matter next week.
Lordship, this
After-
report may be called by the registry, Lordship. To the registry, Lordship.
So the registry.
Yes, Lordship,
Through the
because order is
registry.
submitted.
Okay.
Yes.
What did you say?
List the matter after week.
After a week.
After.
Okay, after a week. After a week would be vacation. Probably.
Yes, it will usually come after breakfast.
Okay.
Right, Lordship.
Lordship, my senior is standing on his leg in court number 1. Kindly matter may be
After-
passed over.
Time being.
Deeply obliged.
May it please Lordship,
Yes.
this is a subsequent bail application. The accused was arrested on dated February 11, 2025 and following 128 days under the remand of judicial custody.
Just a minute. Whether respondent number 2 is also present?
Yes, Lordship.
You have respondent number 2.
Victim, Lordship, victim.
Hmm?
On behalf of victim. Lordship.
Oh.
Lordship, on dated 15th May, the incident matter was
Just a minute.
fixed for
Just a minute. This is bail only. Bail.
yes,
For regular bail.
yes, Lord.
Let us see the FIR. Where? Let us see the FIR. Okay. So this is allegation against.
Yes, Lord.
How many accused persons are there?
There were two accused
Two
persons.
accused. Okay, you are for the one. When let us see the rejection or bail rejection order.
Yes, Lordship, will come page number 23,
20,
22.
this was rejected on. Okay. Bail was rejected.
Yes, Lordship.
When you were arrested, how
February
long you have been inside?
128 days till this day. 28 days till this day.
So charge is filed.
Yes, Lordship. This is charge sheet matter already.
Okay. Trial, what is the status of the trial?
Evidences. The statement has already been recorded, where no incrimination evidence was found against the accused, Lordship.
Okay. Statement means the evidence already recorded.
The
Evidence
statement of the alleged victim. The victim.
recorded by the court.
Yes, Honorable Special Judge.
Okay. So that means charge was framed against him.
Yes, Lord.
Under what are the section charged against him?
Section 70 close to 137, 127 of BNS and section 6 of POCSO Act.
What is this 70?
Kidnapping and wrongful restraint.
Gang rape.
BNS, BNSS, BNS, sorry. Only BNS. Gang. 137.
137 is kidnapping.
And 127.
Wrongful confinement.
Also 6 of POCSO Act. It's 6 or 4?
Six. Lordship, 6 is 6.
Of the under section 27 capital Lordship. 21A and 27 small a is bailable Lordship in fact. Oh, this is NDPS?
Yes.
Lordship. Okay. 21A. 21A and 27A Lordship. What is 27, the punishment in 27A? 27 small a Lordship.
No, Lordship, actually, initially, this
Just a
application
minute.
was filed,
Just a minute. NDPS.
filed on 9 May. And the CD was called, and the next date was on 15. In that day, CD couldn't be received here. So CD finally arrived on 22 May, wherein the status of the case was changed. Section 27 capital A has been inserted after investigation. Therefore, the bail application was withdrawn with a liberty to file a press. Because 21 small a and 27 small a is bailable. Only the 27 capital A is non-bailable. And now
21.
21 capital A, Your Honor.
Small a, small.
No, no,
21
capital,
is not capital A, it's a small a.
no.
21.
Capital A has been inserted after
In
investigation.
21 also.
27A, Your Honor. Sorry, my lord. I have already been in judicial custody for more than 70 days. And all the accused person, the person, the main accused person who has been named in the affair has also been granted bail. And those running CSP,
No, this may extend to 20 years also.
Yes.
Then this 60 days will not work, then it's not more, not be less than 10 years. Then it will be difficult.
Lordship, whether the offense has been committed is a subject matter of trial. At this stage, I have already spent more than 70 days. The investigation has been completed, charge
Now,
sheet filed.
The register section is 27A.
Yes.
So what is then the statutory period?
Now, section 37 comes into play.
Hmm. Then in that
There
case,
have been certain conditions. Number one, PP has to be given opportunity of objection,
Hmm.
and the court has to satisfy that there are reasonable grounds for believing that the accused is not guilty of the offense, and the accused is not likely to commit the offense further. These are the conditions prescribed in the section 37.
Yes,
So,
to satisfy lordship.
yeah.
Yes, to be satisfied, but the lordship, as per the earlier bail rejection order, he happened to be the habitual offender, lordship.
he happened to be the
Habitual offender.
habitual. Earlier
Yes,
also he was arrested in connection with some other
Yes,
Yes.
similar
yes,
case.
yes, sir, yes, sir.
There is a record.
Yes, in the lordship bail rejection order, lordship is at page number, lordship. Lordship page number.
Reflected in the rejection bail order. Bail rejection order.
Page number 24, Annexure 4. It was rejected
Okay.
by Sessions Court.
Page number 29, lordship. Operating person is at page number 29, lordship.
Which PS case this is?
All of PS case, lordship.
In page 24,
29, lordship.
29.
Yes.
lordship.
What is this? 24 is also is bail
20
order
24 is, Your Honor, bail granted to co-accused persons.
for accused.
29
And
is
27 is
27 is the rejection order in Sessions Court.
rejection.
Initially, offense was bailable. Initially, the offense alleged was bailable. 27 small a and 21 small a.
Initially,
Yes.
but then
Now,
after investigation, they have found out and inserted
mm,
or enhanced the provisions
yes.
offense. I mean. Where do we find that he is also involved in some other case?
Lordship, yes, in page number 29, the lordship, page number 29. The
Yes.
first paragraph, the accused being a habitual offender and also a drug supplier with criminal mind and using digital illegally. Further, the investigation being at initial stage and the eye of the case.
This was at that moment. This time. 1 5. Okay. So at that time, the 27 capital A was also not there, but still his bail was rejected.
Yes.
Now that the offense also enhanced, that is 27A is also there. Then in that case, what is the statutory period? It will be
What is the
90
180?
180.
Under
So
section
then it will be
30,
However-
difficult.
under section.
However, my
38.
lord, already investigation will over. Charge sheet submitted. Not
Charge sheet already submitted.
Yes, Your Honor.
Is this a charge sheet?
Yes, yes. Starts it.
Okay, well, then thereafter, the court has initiated the trial.
Yes, yes, if his appearance is fixed on lordship, the first of July month, lordship.
For appearance,
Yeah, for appearance, lordship.
1st of July.
Yes, 1st of July, lordship.
Yes, sir.
Whether the copy was served,
No,
copy was
only
found,
only in
not
the appearance the copy will be served
only
of
on
the charge sheet.
copy will be served,
Yes.
and thereafter charge will be filed. Now, under the circumstances, it will be a little difficult because section involves 27A. So the court frame charge against, then you make an argument before the trial court that this in insertion of the 27A, capital A, you pray for that. If it goes, automatically bail will be granted.
In that
If
case,
it
that's
doesn't
bail.
go, then further time probably will be required.
That's a liberty may be given to approach the sessions court in.
Okay.
That
Okay. Hard, Mr.
Amended.
Amended, non-counsel for the petitioner. I've also heard Mr. Gloria, non-PP. So this order will pass. Bail will be rejected with liberty. Okay. Okay. So this insertion is later on only.
Yes.
Not in the later on only after.
After more than 40 days.
Filing of charge sheet only.
Yes.
Okay, that will happen. Okay. Good point.
May I, Lordship?
Just a minute.
Item number 11, Lordship, I is for delay, it's a delay there is a delay of 501 days in filing this appeal petition. Against the ex parte,
Okay, this item 11.
yes, Lordship.
Yes.
There was an ex parte judgment and decree against dated 25/5 of 2022, which I came to know, Lordship, on the strength of civil warrant issued
What is this case about? RFA.
RFA, regular parts appeal.
This is for condonation.
Yes, yes, Lordship.
IA is for condonation.
Yes.
For how many days?
500.
Hmm?
Counting from the date of judgment, it's 501. Since Lordship, this is an ex parte judgment as per
Ex parte judgment?
Ex parte judgment. As
You have
per-
objection?
Yes, serious objection, your lordship. Apart from that, they are complying the order, your honor. How they are
So that's,
coming to appellate court before your RFA? They are complying, they are paying their amount.
That is different issue. That's a lot. I'm paying there, but since Lordship,
They are very much aware.
Limitation Act says that from when you come to know about the date of judgment, from there the limitation is started.
Can we just see?
Yes, Lordship. Section 123, Lordship. of
Limitation Act.
Limitation Act.
Limitation Act.
Otherwise, there are two more respondents are also there. 2 and
Okay.
3.
Lordship, section 123, that is page 33 would be. Part 1, application in specific case.
Just a minute. 1, 2.
1, 2, 3, Lordship.
Yes.
Lordship, says to set aside a degree pass ex parte or to be heard an appeal degree or heard ex parte. That is 30 days from when comes to know about the judgment in degree. The date of the degree or where the someone of notice was not duly served, where the applicant had knowledge of the degree. It says, Lordship, since Lordship, this is an ex parte judgment and order.
Side. When the applicant
Yes.
had knowledge of the decree. So you came to know about the decree when?
When Lordship, there was a civil warrant against me, issued against me, and on the strength of the
In
civil.
execution.
Yes,
And
Lordship.
from there, it is 500?
No, from there, Lordship, from there, if you count it, it's not that, from there, I have not counted, but Lordship, that's what I'm saying, from the date of judgment, excluding 90 days, it's 501. But you have, if you counted from the date of,
Excluding 90 days.
yes, no,
Why? It's 30 days.
30 days, not, Lordship, I'm saying from the date of judgment. From the date of when I came to know about the
judgment and order of the impugned order 25/2 of 2022. Only when there was a civil warrant issued against me. On the strength of the civil warrant, I was produced before the
Where have you stated that you came to know about the decree only when you came, civil warrant was issued against you? But then there in the execution petition also notice was not served upon you in the execution.
Yes, Lord, sir.
So you came only when the civil warrant was issued.
Yes,
against
Lord,
you.
sir.
Not prior to that.
Prior to that, Lordship, I had no knowledge of the proceeding.
It's paying since when? Complying with the order since when?
BS that my Lordship, as my elder brother has said, I am paying the amount, and so Lordship, this we can come on the merit that this delay be condoned, Lord, for the interest of justice.
Yes, in that case,
If I am paying, Lord,
3rd December 2024, they have
Okay.
paid 11,77,000.
okay, then almost the
so this was filed on
this was
23.
on
Okay,
23.
after that only, I think,
Yeah,
payment
after
started.
that.
Also, I
Now,
will
since
come.
he is paying,
They have,
delay can be gone on.
And merit will come to me.
Your Honor, may I take Your Honor to the ground which they have taken.
No,
For
they said
condonation
that
of
they
delay.
came to know only when the civil warrant was issued against them. And then after
No,
receipt
they
of,
have participated in the execution proceeding, Your Honor. That I have enclosed a copy of the application which they
then
have.
why, how it is ex parte decision?
That I have annexed,
What is it?
kindly see.
Record of what's called for? File for record, is it? Wait, can you show from the record? Where the record, is this a record? File for record, no. For, because the copy was, all those record of the, all those evidence would be on record, whether he was he participated.
Yes,
Whether he-
I have
he-
filed objection. I have filed objection.
See, if the decree was passed ex parte, it is always good for you also to
Annexure 3.
get it decided on merit.
And good thing is, Lordship, as my elder brother stated, almost, I think more amount has been paid. I'm also not aware of that, but since on December, he has paid 2024, now this 2025.
Ground for condoning the delay. There
Hmm?
is no ground. Annexure 3, page 44, Your Honor.
Page 44.
Yes.
What is that?
Of my objection. My lord got it.
Yes, what is that?
Where the petitioner has filed application, Your Honor, for enlargement of time.
This
under
is what,
section
this
one-
is what, page 44 is filed by, this is execution petition filed by you.
Yes, debtor, judgment debtor. They are saying they came to know only when they have, there was in civil.
No, what you want to show, what you want, trying to show by this, by showing this?
Your Honor, they are saying that when the civil warrant was issued by this honorable court, then only they came to know.
Yes.
But prior to that, they have filed this application whereby they have sought time
Where?
before the learned civil
Where
judge.
is that?
Annexure 3, page 44.
44 is execution petition only.
Lordship, what my elder brother is trying to
No.
say that we had filed this execution petition or in this case in execution petition. That's what he's saying, sir, that we had knowledge about the
Yes,
execution
knowledge.
petition. That's what he's trying to.
This miscase in execution petition
It
was
is in
filed by you.
execution.
Yes.
Filed by you.
Yes,
Yes.
sir.
Okay.
In the year 6/9/2022.
For enlargement.
This was filed on 6/9/2022.
And then since 6/9/2022, how many days?
And the other ground they have taken that he was sick. In regard to that, he was sick and he was under treatment here in Itanagar. But the record shows that he has attended his office regularly. That also I have enclosed the documents on. Who?
No, this, I think, when he filed this miscellaneous application, this period also is counted for the purpose, I think that for delay, for limitation. This was within the limitation. This was filed way back in the 6/9/2022.
Yes.
And according to you, what did you say? When you came to know about the decree? When?
Lordship, after receiving of this,
When?
that I have exactly not mentioned, but Lordship, after filing of this six, it will be counted, after filing of this petition only I came to know, then I on 6/9, no.
Okay, this you filed immediately after coming to
On,
know that.
Yes.
Okay. So this he has filed only after he came to know about the civil execution. Therefore, this prayer probably enlargement of time.
6/9/22. Motion,
Let us say.
Yes, sir.
So go for merit, otherwise
Yes, sir.
it
They
will
have
not, it will
this
not end here.
application.
It probably will not end here because what is the decree, by the way? Decree for
Decrease of amounting to rupees 58,25,000 to be paid.
to pay to you.
Yes, sir.
This was, what amount was this?
Your Honor?
Loan amount or what?
Yes, loan amount.
Okay.
Judgment and order was
It
passed
was
on.
admitted, admitted amount?
This is,
58.
they have not participated in the proceeding.
Okay, that's why.
And
So what was the loan amount, initial loan amount?
is also able to pay some of this. 58 lakhs 20.
No, the
Total-
degree amount is 28 lakhs 25,000. 58 lakhs 25,000.
Yes. I come totally.
Principal is,
There was two check.
58 lakhs
Two check-
25,000 only, Lordship.
The principal amount is?
58 lakhs 25,000.
Okay, this is
Yeah, that-
exclusion of interest.
Yes, sir.
Okay, here you have to pay interest at the rate of 18% per annum. Probably, I think this 18%, some concession has to be there. Probably they will not stop. It's better. Give them an opportunity and with the payment of some fine, payment of some fine.
And
Yes, Lordship, my elder brother is that before this about 11 lakhs already.
generally what happens, you know, in this kind of.
Because it is after ex parte decision probably would not.
But your
suffice.
Honor, now
Even if here also. suppose-
ex parte they have refused, your Honor. There is a clear report.
Now
By
they
the
are
postal
paying, now
depot.
they are paying the peers. Now they are paying.
So
And
therefore,
continue-
this RFE
and
is not
probably
meant in
the
a.
challenge will probably on the interest part. And interest probably is a little high, on higher side.
That can be a discussion outside the court also, that can be settled, no problem. For that reason. But here, since the beginning, the conduct of this petitioner, your Honor.
Okay, you submit your then detail on merit.
And also,
But
Lordship,
Lordship, if my delay is condoned.
No, not agree. That is why if the condemnation of delay, you submit on merit.
Okay,
He
Lordship.
is not agreeing. Or what?
yes, objection is, I have objection.
Huh? Delay, you say.
And also, your Honor, kindly peruse the, I have enclosed.
See, while considering this, the veracity of the judgment and order also will have also some weight. If prima facie, because this is number one is a ex parte, And then the interest I have seen, it's in a higher side.
The interest
It's not,
part,
you see, only because the respondent did not contest, the court has no right actually beyond what is entitled.
the 18% is as per law. That
Hmm?
is all. 18% per annum.
Hmm.
That can be imposed.
No.
I have no idea.
Yes,
Even
but
section
I
34 of
think I'll-
CPC says, it says 6% when there is a commercial transaction. Otherwise,
What is the
18%.
bank interest? What is the bank interest?
bank interest,
9.
up to
You know,
exact interest, I cannot say presently. Banking interest.
but
Per
then
annum.
if he has an objection, then you have to submit on
And
merit.
also, Your Honor, at page 43, the ground which they have taken.
No, not that way, not that way. If you agree with payment of some amount, some fine, the delay can be condoned and we go for merit, what I'm saying.
that
And
is
if you don't agree, then both have to argue on merit, then let him argue, then we'll dispose of on merit.
Lordship, in that case, can this matter be fixed next week? I will take instruction and then
It's
that can be
better,
done.
better.
I'll take instruction.
But then if you want
I'll-
this matter to be disposed of on merit, we can have hearing today.
Yes.
Lordship, in that way, like if my elder brother also agrees, let the delay be condoned and we can come to the merit.
That's what I'm saying.
That's what.
So regard
when
to
Lordship,
delay only,
he has
No,
said
he
before
has
the-
in regard-
no instruction, he
it's-
has no instruction.
In
Because
regard to
it-
delay
it-
only, I
Probably
will,
he has
Because
filed.
Lordship, we have to, even if we are in the opposite side also, we have to see the justice has been done or not.
So that is what I'm
not one.
saying. That is
And
what I'm
Lordship,
saying.
as my elder brother has said that 11 lakhs has already been paid on December. What more than that, Lordship? Just because they had got an expertise by doing any, that will not serve the purpose, Lordship. What the matter, the court has to
That
see
is
is that the
also-
justice be done to the both party, Lordship. In that way, Lordship.
only next week, I will take instruction if,
Instruction, but
whether
it- no. See, this we can have hearing on merit or merit
Hmm.
also. Merit. Because no need to obtain instruction in the delay condonation.
Hmm.
In the main petition, you can obtain instruction. In the delay condonation petition, you see, it's a question of some days.
if case, Your Honor, then my objection may be recorded, Your Honor, then in
Okay.
that case.
Then where have you explained? Which paragraph you have explained your delay?
That Lordship, Lordship, I have said, I was like,
Okay, I'll record your this one, submission, hard Mr. Vijay, Land Council for a petitioner. This is, and also hard Mr. Singh, Land Council for the respondent. AK Singh, Land Council for the respondent. It's a sole respondent.
Yes,
The
there are two
respondent.
more. There are two more respondents.
they were former party in the trial court
No.
below. They're-
Are they appearing?
They appear, Lordship, they appear twice or, but Lordship, they have nothing to do, just the performer party
Of
because.
pro forma.
Um,
No one appears on behalf of the pro forma respondent. Their name also reflected.
reflected, Lordship, right?
Where? Who are they?
A. Timung, Lordship,
Earlier they appeared.
appeared, Lordship.
Okay, no one appears on behalf of the pro forma respondent number 2 and 3 staff. This is an application filed under order 41, rule 3, capital A of the Code of Civil Procedure, read with section 5 of the Limitation Act for condoning the delay of 501 days in filing the connected civil. This is civil revision.
Regular
No,
for the
regular first
Regular
appeal.
first appeal.
In connected appeal, huh? Against. Where have you mentioned against the judgment?
Against the judgment, Lordship, is 25.
Against the ex parte judgment and decree. Passed, a decree dated 25/2/2022. Passed in money suit number 15/2021. 2021. Stop, huh? That. Where have you mentioned, stated the region grounds for delay?
That Lordship,
The grounds, okay, the grounds for delay in preferring the connected appeal has been stated in paragraph.
Lordship, I've stated in paragraph because of I was admitted, I was doing a acupuncture integrated rehab center because of my pain.
No, no, where, which paragraph?
Paragraph 2, Lordship. Paragraph 2. Paragraph 2 entry, Lord.
Paragraph only two.
Yes, Lordship. 2 and 3, Lordship.
2 and 3 of the condemnation petition. No, in the suit, whether you filed any written statement?
No, Lordship,
Okay.
it was expertly, Lordship.
They could have appeared before the learned civil judge senior division by way of filing an application to recall the ex parte order. That also they have not. In the entire execution petition, sometimes they used to appear.
Sometimes they used to appear.
Yeah, sometimes.
They appeared,
Yes, they have appeared.
Execution
Order, I
petition.
have enclosed the order also.
not filed written statement.
Lordship, the proceeding was
They
expertly
have-
since
they have
we had appeared on the
stopped-
execution petition, Lordship. When the execution.
No. In the suit, I'm asking.
No suit, we had never appeared, Lordship.
Okay.
They have sought time to pay the amount. That application I have enclosed.
Submit that. So you did not receive any notice.
I have not.
Okay.
No.
And submit that. The applicant did not receive any notice from the court in the suit. As a result, an ex parte decree was passed on 25/2/2022. It is submitted that the applicant came to know about the decree passed by the court, decree passed by the Lanark court. Only on when have you stated when?
That I have not stated, but only Lordship, in when I.
Only when?
On,
Where have you stated?
on page, that I have not stated, but Lordship, on 44, when I had filed my petition, that is on
Only in the,
6 September 2022, when I filed
only during the month of September 2022,
22,
when,
6 September.
okay. No, that is a date of filing.
Yes, ma'am.
You came to know before that, right? That.
Before that, only on September, only I came to know, then I had filed this.
Yes, that
So
is what I'm
since
saying.
this is on record, Lordship, this may be taken as the date of.
No, that is only the filing date only.
Hmm.
After coming to know, you took some time to engage advocate and then to file this. That is in the month of September only. You
Yes,
came to
Lordship,
know.
no, sir. Month of September.
Where have you stated that you came to know when?
That I have not
the
stated, Lordship.
Execution. No.
Not of.
When you submitted that you came to know when the civil execution. Can you read the paragraph where you have stated?
I have not stated.
The region, the ground.
Lordship, the ground I have made in my paragraph 1 and 2 and 3, that's on my ground, Lordship.
Let us read the two.
Paragraph 2, Lordship. Paragraph 3, Lordship. The applicant begged to submit that after having knowledge of the proceeding, impugn order and judgment and decree, the applicant on his part has acted with due diligence and there is no any intentional negligence on the part of applicant.
Okay. And moreover, during the period, the applicant was under medical treatment for what? Medical treatment for his mental illness due to the infection of COVID-19. And thereafter various medical problems. And thereafter for thereafter, due to various medical problems, he was left with, which left his movement very difficult. The applicant was also under acupuncture, integrated under the treatment. So under acupuncture integrated rehab center at Itanagar during the period from 2/4/2022 to 12/4/2023. No, you have not explained at all.
Your Honor, kindly see this certificate.
Because
This-
at least you could have stated that you came to know only on on getting this information, that information. That is that you could have stated. Why you did not state that? And then delay day to day delay, you have to explain otherwise.
That is their Lordship, but since Lordship, this is an expertise judgment.
Maybe, but when you file the condonation petition, you have to explain that is there, but then that doesn't acquire your right unless you explain the delay. You just simply explain the delay, nothing else. And how do you expect the court will presume that since I have stated that my health was not good, so the court will understand? It's not like that. Law doesn't provide that.
I'm sorry, extremely sorry for that, Lordship, but
And he came to know about the decree only when the civil, what did you say earlier?
civil warrant of arrest.
Okay, when he received a civil warrant of arrest in execution petition filed by the decree holder in the month of September 2022. 22, nah?
Yes, Lord.
Okay, start. And the delay was caused due to his illness and his continuous treatment for his mental health and also treatment at Vidanagar under acupuncture integrated rehab center. And the delay, if any, was not intentional. It was only due to the health problem. He was unable to engage, advocate, and also to obtain certified copy of the order. Start. And since the decree was passed ex parte, and since the decree was passed ex parte, for interest of justice, he may be given an opportunity to contest the case on merit and delay the condone the delay of 501 in filing the connected appeal. Start. Mr. Vikip Singh, learned counsel for the opposite party, decree holder, raised objection stating that the applicant has not explained the delay in day-to-day basis, delay day-to-day delay in preferring the connected appeal. Start.
Lordship, in regard to the medical documents, Your Lordship, I have say something, Your Lordship. This acupuncture integrated rehab center is not at all existence here. The treatment, he said that he was under treatment from 2/4/22 to 12/4/23. In regard to that, Your Honor, here the respondent has filed an application.
Okay, upon having heard the learned counsel for the parties and also considering the explanation given in the above paragraph in the delay condonation petition, this court is of the opinion that the applicant has explained, applicant was prevented by a sufficient cause for not preferring the connected appeal within the stipulated time. Accordingly, this application for the delay of 501 in preferring the connected appeal is condoned. However, on the subject to the condition that the applicant deposit rupees 15,000
Yes, Lordship.
before the registry of this court, which shall be registry of this court. This will go to
the bar only, I think.
bar. Okay.
And
The-
yes.
Okay.
Your Honor, my submission, that part may only be recorded regarding the medical certificate. Very
It's fine,
possible.
it's fine only. Delay condonation petition.
Because
Ex parte-
I understand,
ex
because-
parte. Why you're trying to protect the ex parte decision?
Understood.
The amount so deposited shall be released to the, deposited shall be transmitted to the account of the Itanagar Permanent Bench Bar Association account. Account of the Permanent Bench Bar Association. Stop. This was already registered.
So they registered, Lordship. Not have been, but RFA 09.
Huh? Already registered, but then after, before condoning delay, how it can be registered?
Only after the delay is condoned, then only.
Then only it will be
registered.
registered. It will not be registered
Yes, yes.
unless he deposits,
Yes.
actually. But then it has already been registered.
So
So
that-
then place this matter on receipt of the on deposition of the amount of rupees 50,000, okay? For place this matter for admission, okay? On deposition of the amount by the applicant, okay? This will be placed before the court only after your deposition.
Yes,
You
Lord.
deposit.
Lordship, since the elder brother is in hurry, the matter may be taken up on 2nd of July, Lordship.
Then you
I'll
submit,
deposit-
you deposit today, then
Yes, Lordship. I'll
you deposit first,
Yes, Lord.
then on it will be listed. Okay, after deposition, you just tell them there, since I am depositing, list it.
Okay, Lord.
Okay.
Deeply obliged.
The with the IA disposal, okay? Yes.
Lordship, CD was called for.
It was called for. Yes, item 8. Yes.
Lordship, on 28/5/2025, Lordship, the applicant number 2 statement was recorded. And again on 31/5/2025, the applicant number 2 statement was recorded, Lordship. He was arrested and released on
Just a minute, just a minute. What is the allegation against accused? Yes. Yeah, yes, yes. Okay, so they have appeared, they are cooperating.
Yes, yes.
Then no problem. Allegation is also, it appears.
Yes.
Okay. Miss,
B. Sharma.
Lani counsel for the applicant. Whether they were shown arrested.
Yes, arrested and released on bail, Lordship.
Religion there also, okay. Also had Mr. Deloy, Lanet, public prosecutor for the state of Anticipatory, start of para. By an order dated 17/3/2025. Just a minute, because this order, they would be meeting. Para. This is an application filed by the petitioner under section 482 of the petitioners,
Petitioners. Lordship.
petitioners. They have to write name of both the petitioners. Petitioners, Sri Atul Sharma and
Ankit Mishra.
Sri Ankit Mishra, alias Ankit Misera. Under section 482 of the BNSS 2023. Praying for grant of pre-arrest bail, apprehending their arrest in connection with Nahalagan PS case number 27/2025 under section 316 within bracket 5 stroke 351 within bracket 2 stroke 3 within bracket 5 of BNS 2025. Para. Earlier, by an order dated 17/3/2025, both the accused applicants were granted interim anticipatory bail with certain conditions. Staff of para. In compliance of the order. Interim protection, come on. You were directed to appear before the IR? Okay,
Yes.
with certain condition, with the condition that the accused applicant shall appear before the IO of the case. Stop, para. Not para, continuation. In compliance of the said direction, comma, both the accused have appeared before the eye of the case. On such appearance, comma, when you appeared,
On 28,
on
5
28,
and
appeared before the eye of the case on 28,
28 and 31.
31st
28,
of May,
May, 28
May.
May 2025.
And 31st of May,
31st of May.
2025.
You appeared 2 days.
Yes.
On 2 days,
Which date?
on
you were
28,
arrested?
on 28, Ankit Mishra, petitioner number 2 appeared, and on 31st, Atul Sharma
Okay.
appeared.
Then, okay, then, leave that, and then, in compliance of the said direction, comma, Atul Sharma, accused.
Atul Sharma appeared on 31st.
Appeared before the, no, 28, who appeared?
On 28, petitioner number 2, Ankit Mishra.
Okay. Accused applicant Ankit Mishra, alias Ankit Mishra, appeared before the eye of the case. And on 31st, 31/5/2025, accused applicant Atul Sharma appeared before the eye of the case. Stop. On their such appearance, comma, the IO
On execution of bail for the protester.
recorded. IO recorded their statement, police statement, and shown and arrested them in connection with the Halal PS case number 27/2025. Stop. And they were subsequently released on anticipatory bail on the strength of the release on bail, on execution of bail bond on the strength of the interim anticipatory bail passed by this court on 17/3/2025. Stop. The Lanat PP produced a case study, and while referring to the record, submits that the accused has cooperated and appeared before the eye of the case, and their father and their custodial remand. Custodial interrogation is no longer required. Stop. In view of the above, the land council for the applicant submits that since the accused applicants are cooperating and cooperating and appearing before the IO for investigation of the case, the interim anticipatory bail granted to them on 17/3/2025 be made absolute. Stop. The Lanat BP has also not raised serious objection as the accused applicant accused applicants are cooperating with the eye of the case. So in view of the above, the interim anticipatory bail granted to the accused applicant on 17/3/2025 is hereby regularized and made absolute on the same terms and conditions, with the further condition that the accused applicant shall made absolute and absolute stop. The accused shall remain on the bail anticipatory bail granted to them on 17/3/2025 on the same terms and conditions, with the further condition that they'll cooperate and appear before the eye of the case as and when required. Stop. Any other condition? Not required. Okay, stop. With the above this, bail application stands allowed and disposal. Okay.
Much of.
Return the sheet. Nine also passed over. What was this?
Lordship, the deposition was called upon.
Okay, what is it? Can I just,
Lordship,
what is it?
here, Lordship,
Mark.
yes, Lordship, I have marked the Lordship. Here, Lordship, the victim, there are 2 times the victim recorded her statement, Lordship. One is 9/1/25, another one is 5/3/25, Lordship.
This is deposition.
Yes, Lordship. Before the magistrate, Lordship, especially.
Your Lordship, the first deposition was section 164, but on the trial only once it was recorded.
And Lordship, the main part of Lordship, in the body statement, Lordship, the statement of victim is not consistent, Lordship. And that's why, Lordship, on 15/5, Lordship, on the 15/5, the court has directed to record the victim further statement, Lordship. On that day also, victim partly examine, Lordship, victim statement, Lordship. Why, Lordship?
Just
Yes, Lordship.
Is not consistent.
Not Lordship. And Lordship, the interesting part is
Turn
Lordship.
hostile.
Lordship, not hostile exactly, Lordship, because on 15/5, again, Lordship, the victim examined, Lordship, is partly examined and is directed to FIR on the next date for the further examination. Why not,
Then
Lordship?
she has changed.
No, Lordship, on the 15, Lordship, partly examined only, but statement is not recorded. It's only court, the order is reflected like that, Lordship. The why Lordship victim is re-examined, Lordship, 1-2 times, Lordship, that's why they have likely to, Lordship, change their statement, Lordship.
The victim has changed her statement.
Yes, Lordship, on the 9/1
Before the
statement is
magistrate,
different. Yes, Lordship.
Whether, before the magistrate, whether she implicated the accused.
Lordship, under both the Lordship statement, the accused and co-accused, their name was their Lordship. Yes, Lordship, accused name was their Lordship in the both statement.
Name will be there, but then whether they implicated.
Yes,
the
Lordship, yes,
Commission
Lordship.
of the offense.
Yes, Lordship.
So. The FIR, it was different. She did not say that the accused proposed. Now she is saying that accused proposed.
That's well, Lordship. And the Lordship, and the last order where in the court has rejected, Lordship, on the basis of the ex versus state of Rajasthan, on basis of that order, court has rejected the application. But the other co-accused is granted bail, Lordship, on 25, Lordship, 3, Lordship.
Okay, so this accused should also be granted bail.
No, Lordship, I am not Lordship, just Lordship, because under statement of 9/1, Lordship, his implication was there. Altogether, Lordship, the court has granted him bail, Lordship. All the Lordship record is like that, Lordship. That's why I'm just submitting, fairly submitting on the basis of record, Lordship.
what she has stated before the magistrate? What is the allegation made by the victim while giving statement before the magistrate? Who is the main accused?
Akas Ali.
Akas Ali Lordship.
Okay, this is, okay. So she did not know the name of the co-accused, Saiduls.
Yes, Lordship. As per her statement, Lordship.
Okay,
No, but
she knows Akas Ali.
But in the FIR, it is reflected.
Now she says that they took, but then earlier in the FIR it's different, altogether different. He was given, administered some medicine, took.
Lordship, that medicine passed, Lordship. In the first statement on 9/1, the medical report is there, Lordship, which is corroboration with the first statement, Lordship. Medical report is also there.
The magistrate statement is the first, which one is the first statement?
1/9/1/25, Lordship.
What 9/1? Which statement
date,
for
Lordship.
magistrate?
Yes, Lordship. On
Which
9/1, yes, Lordship, 9/1/25, this is the first statement, Lordship.
First statement means before the magistrate.
Yes, Lordship.
There is second statement before the magistrate.
5/3, yes, Lordship, 5/3/25.
Second statement is also before magistrate.
Yes, Lordship.
Why she was produced twice? How that is possible? So in the first statement, she has implicated.
Lordship. In the both statement, Lordship, the main accused is implicated.
Loss.
But statement is.
Whether
yes,
her
Lordship.
age proved.
Age proof, Lordship, is not there, Lordship. That is part of trial, Lordship.
She is major or minor?
17 years, Lordship, it is count under minor, 18 till 18.
17 years and 8 months.
It's a borderline, Lordship.
Almost 18.
There is a commission of voting, then this consent, whatever, is immaterial. There was a commission.
Okay.
Consent is immaterial, then in that case, whatever her statement may be, initially she implicated, and then thereafter, now also she is implicating, although she traveled, not forceful, but then she traveled. But then since she is a minor, the consent is immaterial.
The age is not certain. Lordship. The age is also not certain. It is actually only 2 months left. She is merely a child. However, she already she by herself given the consent in the statement that she was neither forced or she was kidnapped. But
That is why I am saying,
yes,
that is immaterial.
Yes, Lordship. So that's why
It is possible she must have forced the boy, but then that is immaterial. Let us assume that she forced.
Yes.
But since she is a minor, it is
They too
immaterial.
immaterial.
So that is the point.
The boy is supposed to know that she is minor. That is why probably the special court did not grant bail, refused the bail. But why this? At the gap of how many days this second statement was given?
Lordship, up 2 months, Lordship, almost 2 months.
After 2 months. And what is the second statement? Second statement also she stated the same.
No, Lordship, likely different, Lordship. They.
Now-
Partly different, Lordship. On the first statement, she said that, Lordship, they forcefully they have taken to her till Kerala, Lordship. In the second statement, she deliberately went with them, as she also likely to go is with consent. She joined them, Lordship. That is the different, Lordship, between the two statements.
And where is the deposition?
5/3/25 Lordship.
Hmm?
On dated 5/3/25. I have marked Lordship.
5/3/25.
Yes, Lordship.
This is before the magistrate only.
Yes,
Quick
Lordship.
statement on so and so. This is also before the magistrate only. Where is the deposition before the trial court? Trial began, you said.
Lordship, trial Lordship is begun Lordship. That's why Lordship on the trial.
She was examined already.
Lordship on 15/5 is Lordship, date is there Lordship, partly examined Lordship.
Partly.
Yes, Lordship. But record is not there Lordship. Recording was not there Lordship.
Where do we?
It's 15/5
The
Lordship.
partly
It's the
examined.
Lordship, that side Lordship.
Partly examined one.
Yes, Lordship.
So that, okay. That deposition is not available.
Not Lordship. It's not been recorded. Only that order is like that Lordship is.
That is important. But here, before the magistrate, it has already been implicated. Since how long you have been, the accused have been inside the custody, you said?
Lordship, 128 days in the custody. 28 days till this day.
28 days, but then the charge is filed on time.
Yes,
Time.
Lordship.
Now the after recording of this, you.
Lordship, I want to give a submission for this one.
Who prevents you? Submit?
Yes, it's my prayer. Lordship, the mandatory period of POCSO is 1 year. The statement of the accused should be recorded within the period of 30 days. So
Started.
yes, after taking the cognizance. Lordship, on 11th February, already the accused was arrested, and already 2 times the statement was recorded. But however, now respected PP is saying that it is partly recorded. That is my point. So, and
According to you, it was fully recorded.
Yes, Lordship, the instant matter was fixed for that only.
Record says, victim has been examined partly and is directed to appear on the next date. Because of certain reason, maybe because of paucity of time.
Yes.
It's partly recorded.
No, the instant matter was fixed for evidences, Lordship.
What that is to do with the merit of the case?
Yes, Lordship, I have a second argument to make. Now, this one, the Honorable Special Court has relied on the state X versus State of Rajasthan. This judgment they have given us, and they have rejected the bail. Now, Lordship, in this order itself, it is written that.
Where do we find that?
Page number 23, para number 16.
What is that?
In the last 2 lines, Lordship, it is written that it is only the event if the trial gets.
Page 23 of your petition.
Yes, Lordship.
A part of order Lordship.
A part of what?
Yes.
It is only in the event if the trial gets unduly delayed.
Where are you reading?
Para number 15. The order para number 15. Page number 23, order para number 15.
Para 5.
Yes, para 5, under the para 5.
Okay, yes, over the period.
The second last line, Lordship. It is only in the event if the trial gets unduly delayed and that too for no fault on the part of the accused. The court may be justifying in ordering his.
Unduly.
in ordering his release on the bail on the ground that right of the accused to have a speedy trial has been infringed. Now, Lordship, the balance between the protection of the victim as well as the rights of the accused is not seen here. Already, the mandatory period is over. I have only completed 128 days. And Lordship, there are humanitarian grounds also. I am the only sole breadwinner of the family. My mother is ailing.
It's not a case of unduly delay. Because the recording of the evidence already started and due to some reason, court could not complete the recording of the evidence. And the next date is fixed. 16 July.
In July.
Fixed on 13. Sorry. 16 July.
Yes.
I think after 16 July only. After 16 July, if she gives, it doesn't implicate you, and probably you may, but then before that, what is your submission, by the way?
Lordship, my submission is, Lordship, the trial is already begun, Lordship, as per the latest judgment.
Yes,
expressed in
that,
yes,
but-
Lordship.
But
So-
they have filed their application before and it was rejected.
Yes, Lordship. So, Lordship, they said, Lordship, they have.
I think better you just see
Yes, Lordship.
after 16/7. Because
Because
our
18
examination is
statement, yes.
on the way. After 67, you file bail application. Then what you have, what, there is no other ground for you. There is no new ground for filing this bail application. What is the new ground? Nothing changed, isn't it? Now,
Yes, yes.
the thing is that
No,
the
Lordship,
trial began.
in the suo criminal petition, which the special judge had relied, there it was, the suo was taken because the notice was not served and the bail was given through the special judge. But we have served the notice, we have served through PP, we have served
What notice?
notice to the victim, to the complainant, that we are applying for the bail. That's why the counsels are also here. We have served.
That's a different
And
case.
what is your
Yes.
submission? We are for the victim.
Victim.
Yes.
Lordship, it's up to the discretionary of Honorable Court.
Okay, then why you are here?
Lordship, already statement has been taken.
Not yet. How?
Yeah.
Are you representing the victim?
Yes,
Not
Lordship.
yet taken.
So,
Just begun, not yet completed, fixed on 16.
yes, Lordship, it's up to
Deposition
16
recorded.
July.
On 16, they will also cross-examine.
Lordship, already 90 days are over. And also
90 days is not
Yes,
immaterial now, because charge sheet already filed on time.
yes, that's why charge sheet
That-
has also
That
been
is only
filed.
for the purpose of whether the charge sheet filed or not. Then within 90 days, if the charge sheet is not filed, then you are entitled age of law, age of right.
Yes.
After filing of charge sheet, 90 days, 60 days, as the case may, it doesn't count. That is immaterial.
But Lordship, I have a Article 21 is there, right to life and liberty.
What is that Article 21?
Lordship, if
So what
If-
about the Article 21 right of the victim?
no, Lordship, if nothing is found against me, why I'm still under the remand?
Who
judicial
says nothing is
custody?
there? You want to say it?
No, I have gone through, but
Then,
as per the trial.
and the same thing, she has given police statement, FIR, as per the FIR, no escape. As per the FIR, but then of course, later on she knows you. Given a police statement before the magistrate, twice, same thing,
Yes.
almost repeated. Now she's, the recording of our evidence is on the way. Let it complete. After a recording of evidence, if nothing found out, then
Yes.
it comes, then it will be a change of situation. Now no situation has changed. The status of the case has not yet changed anything after rejection of your bail order by the special judge. Nothing has changed. On the same ground, how do we reappreciate the same argument? How do we pass a different order unless there is an inherent defect in it?
The-
Unless it is illegal order.
The victim may be called upon here also in front of you, Lordship. If
No, no,
because
that is not
already,
possible, Learned Counsel, that is not possible.
Lordship,
The victim-
actually, my prayer, your grace.
That is
I'm-
not the procedure, no, please, learn something.
Yes,
That is not the procedure. The procedure is she have to depose before the trial court, and then
Yes.
she will be cross-examined by you. Take part there, and then after that, you have the copy of that cross-examination, her evidence and cross-examination, and if nothing comes out, then you
Yes, Lordship.
come before this court again, saying that since there is nothing, there is no probability of his conviction under the Alice offense, then you make a prayer. The same court may also release you. Okay.
Then, Lordship,
So,
my
and-
prayer is that, Lordship, bail may not be rejected, but it may be kept on hold.
Okay.
Because the balance between the protection of victim as
Then you
well
see,
as.
then here in this bail application, nothing has changed. What I'm saying. Then in that case, you have to improve your petition again. Then the status of the case has changed. How many money you have spent here? What loss will cost to you? Because I'm saying for you only.
Yes, Lordship.
This is for your benefit only.
So that the
If you
new
file
resolution
after the
can.
change of the status, that victim has already been now examined. Now there is no possibility of any hampering, tampering,
Yes.
or influencing with the victim.
Yes.
And then since there is nothing against the accused, the victim has not made any implication against her. No incriminating material, no implication. Then you can apply for bail again. That will be better.
Lordship, but it may be kept, this is my prayer, only, it may not be rejected, but may be kept on pending.
I'm rejecting.
My lord, if this would permit, then I would like to submit that. This bail application may be pending for some time, for till 16, and this court have can call the scanned copy also next after deposition.
There, at the time of filing this bail, what you have stated, when this was the recording of 15/5. The two are. The council should also learn when to file bail application. And you could say sometime you should wait for some point in your favor. Because this half examination was done on the 15th, on the same day this your bail application was rejected. And see, you are, before completion of the examination, you have filed this bail application untimely, not calculated, did not apply your mind, Did apply your mind. See, only subsequent filing will or does not entitle you or acquire any right for granting bail. Okay, if you want to keep it pending, but this is on time. Mr.
SNT.
Learned Counsel for the petitioner.
Then the matter may fix after 16 lawsuit.
Yes.
So updated trial court record may be called for.
See how this is. The advocate need to act promptly, but then should also apply your mind. While
No, so my submission like that lawsuit, it may be dismissed, but if he lawsuit praying
Yeah.
also like that lawsuit.
no, this is, I don't know why you are insisting not to dispose of
Yes, lawsuit.
when. This is
He may be filed lawsuit new
filing bail
petition
application is
lawsuit.
nothing, what I'm saying.
My lord, actually,
What is there in this bail application?
no, that's why.
You have written something,
No,
precious things.
my lord, like that only. We are getting some problem in this for withdrawing and my prayer that this may be kept for abeyance till this after 16 the new development will report this before this court.
Mr. Sachin, counsel for the petitioner, some is that since the reposition of the victim before the Line trial court is due on 16/7/2025. Therefore, praise for listing this matter after 16, after date, start of prayer allowed, the prayer not objected. List this matter on after 16, huh? Okay, after 16 July. Okay, return the case diary. This is not case diary. This is
Lordship, no, it's a TCR
scanned
record,
copy of the
TCR lordship.
scanned copy only.
Yes, lordship,
Okay.
scan copy.
Return the TCR. Okay.
Yeah, no, sir, updated scan copy of TCR may be called for lordship on next date lordship. Updated TCR lordship.
Let them pray.
Lordship,
They want to
bless.
apply lordship.
Okay.
May I, Lordship?
Yes.
Lordship, I want to withdraw the present petition. So I may be allowed to withdraw the present petition.
You are appearing on behalf
In
of
Titorum. Titorum.
Titorum.
Yes.
Where is the respondent? Have you informed the respondent that you are withdrawing?
I have been instructed by the senior Titorum.
They might also object. Just a minute, huh? You have been instructed.
Yes, Lordship.
See, once you withdraw, then you will not be able to file again.
Yes, yes.
Okay. Mr.
Entaro.
Line counsel for the appellant submits that he has an instruction to withdraw the appeal. Your name is there in the cause list?
Lordship, in Bakalat nama.
It's there.
Yes.
Okay. This appeal is dismissed on withdrawal. Okay.
Highly obliged.
There is a record also. Okay, return the file code record. Whether IA was disposed of? IA is for what? Okay. The same in IA also. Huh? Okay.
Yeah.
May I please, Lordship?
Yes.
As per the office note dated 17/6, the service report upon the sole respondent is awaited. However, my learned friend will be appearing on behalf of the sole respondent.
So you are appearing on behalf of the respondent?
For respondent.
Sole respondent?
Yes, my lord.
Yes, Lord.
Okay.
So, Lordship, may kindly consider that the service is deemed to be completed.
Okay. You are Mr.
Mr. L. Sangam. L. Sangam. My name is not there in the post list, however.
Mr.
L. Sangam, Lordship.
Your name is there in the course list?
My name is not reflected in the post list, however, I find the Bakalat.
File Wakalat, huh?
Yes, Lord.
And a counsel to that. appellant. Mr.
Remove Riva for
Appearing
respondent.
for the first time,
Yes, my lord.
Put appeared on behalf of the sole respondent.
My lord, we have not received the copy of petition.
Okay, and some is that
I will serve a copy.
they have not yet been served with a copy of the memo of appeal. Stop. Mr. His name, counsel for the appellant shall furnish a copy of the appellant appeal, a memo of appeal to the learned counsel appearing on behalf of the respondent. Today itself.
Within 2 days.
Within,
2 days, 2 days.
Within 2 working days from today. Start.
Lordship, kindly fix this matter for exhibition hearing after
Since the
some
parties are
modifications.
being represented. List this matter.
On 24th July,
24th July for admission.
admission hearing.
Whether record record was called for here in this case.
The record was not called for on the earlier occasion.
The record would be needed. Whether the record would be needed or not.
Record might not be needed.
No, the AP is already admitted.
Yes.
What
Notice has been issued. However, the service was
Okay.
service had incomplete. So now that my learner friend is
record,
appearing,
whether record is necessary.
record might not be necessary, Lordship.
If record is not necessary and since the matter has already been admitted, then it will be listed for hearing only.
My lord, it's first time, so we'll file affidavit and reply.
Lordship.
This seems admitted.
It is admitted, yes, Lordship.
And then it will be listed, then since respondents are appearing.
Oh, respondent is appearing.
Yes.
Very well, the Lordship will fix it for hearing then.
That is right.
Yes, Lordship. I'm
My-
grateful because cause list did not show anyone on the other side, so I
Yeah,
was
that-
wondering whether service is
My
complete
lord,
or not.
We will have to file the reply in this.
You want to file?
Yes,
Affidavit.
therefore, my lord,
Affidavit.
sometime may be given
Okay.
an affidavit.
Then the learned counsel have to.
On 24th of July, then Lordship, after the vacations then.
Okay. Wants to file affidavit, therefore pray for affidavit and pray for some time. Prayer allowed. Is requested list this matter on
24th of July,
24th of July.
because now vacations are coming.
For
24th.
hearing. In the meantime, you file.
Yes, in the meantime, let them file
In the
it.
meantime, the respondent may file affidavit.
If so advised.
Okay.
Deeply obliged, Your
My
Lordship.
lord.
24th July लिखा है ना?
Learned counsel is reflected, huh?
Paper book we have received, Lordship.
Yes, this is criminal appeal.
Matter may be fixed for
Hearing.
admission hearing.
Admission hearing.
Yes.
Is criminal appeal?
Yes,
Yes.
Lordship.
Why admission hearing?
For hearing.
For
Lordship.
hearing, my lord.
Since the paper book is also
Yes, that's
ready, have you received? UFO?
Respondent number 2, Your Lordship.
Respondent number
2.
For victim, my lord.
or victim? Mr.
M. Loji, my lord.
Hmm?
M. Loji, my lord.
M. Doje, Marge Doje,
Yes, my lord.
Learned counsel for the appellant. Also had Ms. El Hage, learned additional BP for the state respondent and Ms.
B. Palon.
Learned counsel appearing on your legal aid counsel or private?
Private.
Okay, learned counsel appearing on behalf of the respondent number
2.
2.
Yes, Your Lordship.
Victim, staff, apparent. The paper book has been prepared. Copy of the paper book have been received by all the parties. Stop. In view of the above, list this matter for hearing after 3 weeks. 4 weeks.
After 3 weeks.
After 3 weeks. Okay.
All right.
And for the petitioner, Your Lordship. Lordship, on the last hearing, Trial court records were awaited.
Whether, have you received the record? Trial court record? Yes, it appear received. Then if it is appeal, then the paper book need to be prepared.
Yes, Lordship. Lordship, victim side Lordship, no one appear Lordship. Then legal victim Lordship for is this
This is
POCSO
also
matter.
POCSO?
Yes, Lordship.
Yes, Lord.
Then LSC may be appointed for the behalf of the victim Lordship.
Okay.
Notice been served Lordship, but no one
Notice was
appearing.
served.
Yes, Lordship.
Mr.
VT Gurum. VT Gurum.
Yes. Your name is there?
Wakalat Nama, yes, Your Lord.
File.
Yes, Your Lord.
Vicky?
VT.
VT.
Yes.
Okay. A rightful name, huh? Learned counsel for the appellant. I've also heard Ms. El Hadi, learned additional DP for the state respondent. No one appears on behalf of the respondent victim. Although notice was issued.
Yes, Lordship.
There is a IA also. Yes. There notice was good. Okay, although notice was served upon. The respondent number 2 victim pro his father, Papa. It appears that the respondent number 2 is unable to engage private advocate to represent their case, represent her case. So, in view of the above, the register come secretary, High Court Legal Services Committee is directed to appoint one legal aid counsel from the panel of advocate of legal aid counsels of the High Court Legal Services Committee to represent the respondent number 2 victim staff. List is okay.
Your Lordship, after the
Since the trial court record has been received, the registry is directed to prepare paper book and furnish copy to the councils for learned counsel for the parties and place the matter
after holidays.
For hearing after
Holidays.
huh?
After the holidays.
The court vacation.
Okay, then after furnishing a copy of the paper books. At least it after 4 weeks. They might take more than 4 weeks also.
Yes, Lordship.
Okay, yes,
Oblige, Your Lord.
yes.
Oblige.
This is 14, 15.
15 Lordship.
So rest we will continue at 2.
Lordship.
Yes. It was to be represented by the legal aid counsel. Who is the one?
Jail appeal, lordship. Jail appeal, lordship.
Legal aid counsel.
Yes.
Who was the legal aid counsel who represented earlier?
So this is the first time of it.
Okay. It appears that the appeal memo was prepared properly. So this probably was prepared by the legal aid counsel only. Affidavit also signed. I have no idea if this is a regular appeal because it appears that it was filed by the legal aid counsel.
Yes, Lord.
But it has been registered as jail appeal. The jail.
Lordship, there is a punishment under 376, but no private respondent was there, Lordship.
So that is why it need to be pleaded. So this appellant need to be represented by the counsel.
Yes.
Who would then be directed to implead the victim also. This jail appeal has been listed. However, no one represented the appellant staff. The registry shall examine as verify if any legal aid counsel the cause list shows that the appellant is represented by legal aid counsel. However, no one appears on behalf of the appellant staff. No name has also been reflected. Sorry, the name of the legal aid counsel has also been is also nowhere reflected. Staff. The registry shall verify if a legal aid counsel was appointed by the High Court Legal Service High Court Legal Services Committee staff. If not, then the registry cum secretary High Court Legal Services Committee shall appoint one legal aid counsel from the panel of legal aid Legal Counsel of the High Court Legal Services Committee to represent the appellant. Stop, list it after 3 weeks. Okay. Okay. What is the allegation? Is where is the complaint? 24? Why don't you file the copy of the FIR separately? This is too small. Where is the FIR? What is the value? What will do with all this? The allegation, when you file this, the allegation is necessary. What is the content of the allegation is needed to be seen.
Page 23, 24, Lordship. There's no type copy, only all the.
Type copy you should file.
Yes,
It's
sir.
only very small
Yes,
font.
sir.
It's very difficult. Don't depend on such documents. Huh? This because this is in the format. It's very small font size. You should have that. You read it. Where are you reading?
With due respect to number submissions that are not being legally acted by city soil slope. This accused person is in the petitioner number 2. Along with his name members, that is 20 August 2022 at the job. Further, it is pertaining to 19 years that they were big plans attack me as some years back. You know, who are insurance. Further, having appeared with his wife, the allegation is appeared with his wife. That is basically the suspicion. Appear with his without any open making understanding that I must be required. So, without that, that is the reason why they would be attacking. From Ireland, it's that they are almost unconscious. Further, my behavior have been needed by it is almost clear to all. This is the allegation. The allegation is fighting is arose because petitioner number 1, who is the victim of the complaint, was this relation with my wife. Petitioner number 2. So other the points are the my co-brother. Who were already entered in the conflict. The settlement is below page 52.
52 is settlement. 52 is settlement.
52 is the money. Then 53 is a settlement.
Money received for what?
I have here of all the expenditure, the compensation I have given. So, then they call the that is after paying around 50 October 2024, really accepted down and the settled the matter allocated to the party. So therefore, we are responsible for 20. 20 So in this regard, Honorable Supreme Court was already settled down. In State Bangladesh.
What it says?
State Bangladesh. Matter is settled where between the parties, immediately relation is on a legal also can be compounded.
On a 326 also?
326. And 48 days of the this honorable court has already was the rely upon the same claim.
What is the status of the case?
Three cognitions is there.
Hmm?
Three cognitions. Cognitions of the been taken by the army. The speed line also, there are within of the south, there are 5 of this. In that judgment also, very much clear. It is partly settled, mutually settled is better, then it can be qual. HN Pandu Kumar, this is the latest way out. Settled down by Honorable Supreme Court.
Yeah, Customary. So this is from JMFC.
Yes. It is pending report under the jail.
Yes, what is your summary?
Yes, Lordship, as per the Lordship, the Honorable Court, the Supreme Court has Lordship, they have observed the Lordship, even though the grievance hurt is their Lordship, if both the parties mutually settle and the compensation is been paid off Lordship, then it can be Lordship compounded. Even in the Lakshmi Narayan also Lordship, the court has viewed that in the private nature Lordship, if the both the parties settle, that it can be Lordship. And in this case, they have mutually settled their dispute and as well as they have compensated Lordship. So in that case, Lordship, if Lordship has, because in the trial also Lordship, if it is blink of conviction, then Lordship, it can be fatal of the Lordship, proceeding of the law Lordship. This Pantakumar lordship is here lordship, after conviction, it is compounded lordship. And in this judgment lordship, he has, after conviction, this court has, again, it is lordship compounded the offense lordship.
In which case?
In the Pantakumar lordship. Yeah. If after conviction, it is compounded lordship, in this case also lordship, it fit case lordship to be lordship, compounded lordship. Because the both the parties is, they have mutually agreed and they have compensated also. In that case, lordship, in my side lordship, I am leave it to this court lordship. Para 4 and 5 lordship. Para 4 and 5 is operational force page para 4 and 5 lordship.
Even this special petition was also dismissed. Here in this case, the parties were, okay, distant relatives. Distant related and the compromise also was related to the property in the present case, in this case? Panta Kumar?
No.
The compromise covers not only the criminal case, but also related property disputes. That is why, including the right of way. That is why they need to maintain a peace and harmony.
Lordship may pass appropriate order as deemed fit as per, in the interest of justice, Lordship.
That's because this is a grievous injury. That is why I'm looking at it. The punishment is 7 years.
Yes, Lordship.
That is why. Had it been 2-3 years, no problem.
Yes.
But the grievous injury. So what is the punishment in 26? 326, just
326, Lordship.
More, maybe more than that also you could go.
Ten years, Lordship.
See, that is why I'm saying. Otherwise, had it been a small punishment, 3 years, no problem. Used to grant only. This is that is why I'm looking at different situation, different fact and circumstances. This was in exceptional circumstances, exceptional circumstances. Of course, including voluntary settlement. What is the exceptional circumstances in the present case, in your case? Because this is grievous. Otherwise, had it been some other offense, we used to grant.
So that fighting was of sudden, because
It is always sudden. The murder is sudden. It is always sudden only.
suddenly saw the wife was appeared with that one. That's why they fighting, but taking the part. But later on, come to the they are become relative. Then they enter into a settlement. Now both the parties are from same place only. There is no such thing in here.
And then by filing miscellaneous application, SLP was also filed. It was dismissed on demand. It has a story behind it. Appeal is partly allowed. The conviction was confirmed only. See where it is the settlement. The conviction is confirmed. The sentence were only, of course, because of that reduced. Conviction was confirmed. Have you seen this? Where is?
After conviction,
After conviction in the appeal for the reduction of the sentence, that was agreed, not confirmed. What is it? Read that last sentence.
But otherwise, this matter was appear where this will be taken another day.
You bring the you bring was it right?
IA was, there was one IA in this matter. IA was disposed from 27 to 2025.
IA for what?
For the implement of one of the accused. That has been not included in the.
One of the accused.
Yeah, one of the. In the main investigation that has.
Okay. Has it been incorporated here?
That order, another IA was, I had removed, that was, order has already been passed.
No, but then
Yeah.
it's not there.
Yeah.
Then you have to, I think, change your course title, impleading him also.
Honorable Court was given direction to the registry to amend the cost.
How the registry will amend unless you file amended course title? You file amended course title.
Please be wrong. I may be allowed.
Yes, otherwise for that again you will have to file over and again another petition. Where is the IA?
Was disposed of on 27 May 2025.
No order was passed in the main case.
No, not in the main case, but I separately moved the IA.
No, then
IA 22 was for like.
yes, you are correct. It's better that I did not pass immediate order. Because otherwise you will have to file another over and again another petition.
There must be two IA. IA 22, that is for the implement application.
And 29?
And 29 is for the corrections of the debt order, that impugn order. 18-3, 2025, IA 22.
Okay. Third, Mr.
For the
For the
upper.
upper Learned Counsel for the petitioner. In view of the order passed in IA Criminal 22 AP 2025. Order passed on 18/3, huh?
Yes,
18/3/2025 in IA Criminal 22 AP 2025. And order dated 27/3/2025 in IA Criminal 29 AP 2025. The who is to be implemented?
Accused number 4.
Three. What is his name?
Rido Tarak.
Rido
Rido Tarak.
Tarak.
Yes.
Is implemented. Petitioner number 5. The applicant, the petitioner shall amend the course title by including Rido Tarak as petitioner number 5. Within a week from today. Within a week or how many days?
After 2 weeks.
Okay, stop. This is matter after
Within 2 weeks.
this is matter after 2 weeks. See, it is good that it did not pass. Otherwise, you would have been the loser. Because one accused again for that again over and again.
Correct.
Rectify.
Apply process.
This is after 2 weeks. Later. Yes, there is a scan copy.
Yes, scan copy lawsuit.
Okay.
Updated scan copy then lawsuit.
Okay. Updated one.
Yes, lawsuit.
Then is there a stay?
Yes, interim state.
Interim. The interim order passed until the next date. Next date of this thing. Okay.
Great group.
Apply process.
Yes. Yes, please. You're Mr. T. Minky, current counsel for the petitioner. Press 4 and is granted further 2 weeks' time to take steps upon the respondent number. Respondents. Okay. You were directed to take steps.
Yes.
By a registered post with ID.
Yes.
Just a minute. Okay, the petitioner shall take steps. Just a minute, huh? Notice was. The petitioner shall take steps upon the respondents by a registered post with AD as well as by usual process within a week from today. Stop. This is matter after 4 weeks. Okay. The interim order, there is interim. The interim order passed earlier shall continue till the next day. Next date of listing. Okay. Yes. You are for the petitioner. Service report upon respondent number 2 is still awaited. Already filed Wakalatnama. Not on record. Wakalatnama has been filed. It's respondent number 1, but then 2 not yet filed. Wakalatnama filed, then their name reflected is 20. Okay. Mr. M. Your name is there. Your name is not there. Mr. M. Land counsel for the petitioner. No one appears on behalf of the respondent number 1, although the name of the counsels who filed Wakalatnama has been reflected in the course list. Stop. The service report on respondent number 2 is still awaited. In view of the above, list this matter. After 4 weeks, then in that case, when did you take steps upon respondent number 2? You took this week only. Step, when did you take? Now, when did you take steps? Well, have you taken steps upon respondent number 2? When?
The next day.
Next day itself. Then probably. Okay, April. It should have been, then probably it has not reached. This is civil. I think you better take fresh steps because it is not returning even after 2 months. You take fresh steps? Okay, start. Then in view of the office note dated 17/6/2025, Mr. Ete, Land counsel for the petitioner, praise for allowing him to take fresh steps upon the respondent number 2. Stop. They are allowed. Steps upon respondent number 2 within 2 by a registered post with AD, as well as by usual process within a week from today. Stop. At least this matter after 4 weeks. Okay. The interim order passed earlier shall continue till the next date of listing. Okay. None appears on the none appears on code. Service upon the respondent still awaited. Stop. In view of the above, list is matter after 3 weeks. After 4 weeks, this is item number 21. Okay, after 3 weeks. Yes.
Also, this is JLFL Lordship. Yes, Lordship, Legal Aid Council Lordship. There is a Lordship, 2 years, 5 month delay in filing this appeal Lordship.
So then in that case, legal aid counsel need to be.
Yes, Lordship.
This I is for what?
I is for condonation of delay up to 2 years.
Okay, then someone has to represent
Yes,
the
Lordship.
applicant. Delay application was filed by whom then in that case? This is 22.
Yes. By the
22 legal aid counsel, not named.
Not named Lordship.
The record reveals that this jail appeal has been filed by the convict Takenga Gami through legal aid counsel. However, no one represents the appellant. No, and no one represents the appellant. No name.
Appellant
also
name,
been-
Lordship.
Hmm?
Appellant name, Lordship.
Of the legal aid counsel.
Legal, yes, not there.
No name of the legal aid counsel is also been reflected. In view of the above, the registry is directed to appoint one legal aid counsel to represent the convict for filing to represent the convict in both IA number 52 AP and criminal appeal J number 11 AP 2025. Stop. List this matter after 3 weeks. Okay. Hmm. Yes. Not by the state. No, by Dusty, you were allowed to take steps by way of Dusty. By which order? Okay, this is delay condemnation. In the condemnation petition. Okay, yes. You have already taken steps
Yes,
by way of Dusty,
by way of registered post, Your Honor.
not by Dusty.
No, by
Now you
Dusty.
want to take by Dusty.
No, Your Honor, it's already been served. Service is already
They have
completed.
received.
Yes, they have
They have
received.
received.
Yes,
Where do we find?
Your Honor, in that manner, Your Lordship, I would like to make a prayer that I may be allowed to file an affidavit
Affidavit for what?
for bringing to the records for the completion of the
registry.
service.
Registry, it will come to the register.
Your Honor,
Registry. And it will be recorded.
Registered-
If you have taken steps upon the respondent by way of Dusty, then only you will have to file affidavit, compliance affidavit. But then if it is by way of register,
Your Honor, herein what
with
happened?
AD,
Your Honor, herein what happened is that it was directed to take by Dusty mode,
Yes.
but however, the service was taken through registered post, Your Honor.
So that is why when you were directed to take steps by way of Dusty, why you did not take steps by way of register post? Now the court will be insisting to file affidavit and take steps upon by Dusty way and file affidavit, but that unless that record comes and then unless the respondents are represented.
Your Honor,
No, you have taken it appears. The registry has recorded that you have taken step by way of Dusty service.
yes. That's what I'm explaining, Your Honor. Because
You've taken by way of Dusty service.
at first it was directed to take by Dusty mode, but what happened here is that registry did not take any steps, but we sent it through the
No,
registered post.
the office note reflect that the applicant has taken Dusty service of notice upon the respondent 1 to 5 on 27 March.
Yes, Your Honor.
That means you have taken, you bring on record, okay? The Miss Riba.
D. Riva.
Land Council, D. Riba, Land Council for the applicant, some steps. Although this court has directed to take steps upon the respondent by way of Dusty mode. However, the petitioner has taken steps upon the respondent by a registered post with AD. With
Your Honor,
AD.
no, not AD.
Register post. Stop, huh? The office note dated 17/6/2025 reflect that the petitioner has taken, however, the office note, dated 17/6/2025 reflect that the applicant has taken the justice service upon the respondent number 1 to 5 on 27/3/2025. Stop. Be that as it may, comma, as prayed for, comma, the petitioner shall file compliance affidavit within a week from today. Okay.
Much obliged.
Compliance affidavit.
Lordship, there is no interim order in the case. So this matter is on prima facie, this is a civil matter. Even then, criminal case has been registered, and as per the
Who appeared for respondent number 2?
It's already yes,
For respondent number
they are
2.
the party. That is matter may be heard on merit, so that interim order may be passed. Interim order, because I have filed this bail application. It was rejected on the ground that this conduct of the petitioner was not good. Because
Okay, now the conduct of the petitioner has changed.
no, it is on merit. It was that within the prescribed time, the petitioner could not appear before the eye of the case. That is why Honorable Court has decided it is a better case not to grant any interim order, not this anticipatory bail application. Bail. So on merit, if it is seen on record, page number 15, annexure 1, kindly see it is a completely a civil matter. Matter is, kindly see, as per the complaint.
Just a minute.
There is nothing as such showing that there is any criminal element involved in the case.
It is criminal petition, just
yes, criminal petition. That is why page number 15, kindly read in detail, annexure 1. This is the FIR.
Yes, sir. What is? What is this order?
As per the this the lordship is aware of the Bhajanlal case.
No, this is in some other.
Page number 15,
What is
annexure 1.
AB?
Not AB, it is a criminal petition. AB is already this.
Why this AB's order is here?
AB is not connected with that has been already
Then why this
separated.
order has been placed?
That is the registry. AB is not connected here. AB is already disposed of also.
Disposed of?
Yes.
Not
AB is
connected
no more
with-
here, not alive. Only remaining is criminal petition. Criminal petition is on merit now.
Okay, how many respondents are there?
Only two. One is state, yes. One is state, another is complainant.
Okay, you are filing any, have you filed any affidavit? Objection, anything? Appearing for the first time? Okay, you file objection then. You file.
Yes, I will file.
Okay, Heard Mr. Tapak, learned counsel for the petitioner. Also heard Ms. El Hage, learned additional VP for the state. And then you are Mr.
Tacha Noma.
Mr. Tacha Noma, learned counsel would appear on behalf of the respondent number 2 and place for some time to file and submits that he want to file objection for which he prays for some, how much time it will be? For 2 weeks. Okay, stop, huh?
It will before break, that maybe because there is a.
Before break only, we have only 1 week, next week only. It will be only after
week
break.
for this hearing over the interim, this interim part. If it is interim
Let
is
them
granted,
let
that
them
is not-
fight.
no
Since they
issue.
have filed by next week?
No, next
2
week.
week time.
For hearing of the
Where,
interim.
where is this, your client
Because
stays?
on prima
It's
facie,
another case or which
there is
case?
no case.
Lordship, in the case study, Lordship, there is a prima facie Lordship case established, Lordship.
Okay,
The
which
victim-
Chibu PS case, okay. List
Before
is better
break.
after 2 weeks. Okay.
Then updated case study also may call for
Wait,
Lordship.
huh?
Updated case study, Lordship.
Okay, on which date, the updated case, on which date? The, who will produce, the
Lordship.
additional PP?
Yes,
Okay,
Lordship.
the additional PP shall produce updated case study.
2 weeks means after break. I
It's
think.
after break only, always, because
Lordship,
we
on
have
the-
only 1
on-
week.
On the
And
next
since
day,
he is appearing for the first time, need to be given some time.
Lordship, on the next day, fix, let the matter, there may be observation that the hearing of over the
Okay.
interim order.
On which,
Interim.
No, Lordship, it may be on merit, Lordship, because Lordship here ingredient is
no,
very
it
much.
will be
Lordship.
merit, it will be on
Yes,
merit,
Lordship.
it will be disposed of only.
Yes, Lordship.
Merit is also there, but there is some harassment, scope of harassment.
No, it's
Because-
harassment where.
What is the offense? What is the offense
Wait,
involved? Just
Why in civil case I should be arrested? That is the issue here.
what is the offense involved? Offense.
Kindly see, Lordship, this is a clear case of, as per the Bhajanlal, I'm referring to.
Lordship,
Okay,
cognizable
When the
offense
matter
is
on
Lordship.
prima facie, if there is no case is made out,
Yes.
in that case,
Okay,
his
after
honorable
hearing-
court is
Lordship,
putting custody.
investigation
We'll
is
dispose of the
not
entire
completed,
matter.
Lordship.
Okay.
That is why
Okay.
on the, if interim order is passed,
Initially, there was no interim order, and most probably, if it was not passed, you may have to
Because
file one,
interim-
you may
interim
have to
part was
file
never
one-
been heard.
If he's,
There was one bail application was pending, or at that point of time, admittedly, there was a bail was granted, but anticipatory bail application. That was granted, but we didn't prescribe it, he could not report it before the eye of the case. That is why, on the latter stage, I have phrased by way of interlocutory application for recalling of that rejection order, recalling order, but it was not accepted. The bail was disposed of.
See, it appears.
That was, that
Your
is, there
conduct.
is a hardship, Lordship. That is why some relief is
No,
required. in
you
this.
make a mistake, and then when something happened to you due to that mistake, and you go
Because
with
there should-
hardship.
Just
No.
Lordship.
Okay, okay, after 2 weeks. Okay.
after 2 weeks,
Next.
Maybe, there should be, there may be Lordship observation
This
that
is, I think-
interim prayer, Lordship. On the
interim
next day,
prayer may be hard on
interim
merit,
prayer-
Lordship.
Interim prayer, because maybe thereafter, so no, since there is a.
And if required, the
Yes.
interim prayer shall also be considered. Okay.
If required, Lordship, if
that may be
on merit, Lordship.
Hearing,
On merit.
Yes, Lordship.
merit may
If
go
I-
on. Lordship.
on that day-
That may take
Just a minute, then.
so many months.
Then it appears that prior to the next date of listing, you have to file your objection, because
Yes.
on that day, otherwise, if you don't file, interim will be granted.
This private respondent will file objection, Lordship. Like, Lordship.
It's finished. Okay.